When a cocky lawyer and a dismissive judge cross paths with Karoline Leavitt, they assume it'll be an easy victory. But what unfolds next? A legal masterclass like no other. The courtroom buzzed with quiet murmurs, packed with a blend of reporters, legal interns, and intrigued spectators. A hushed energy filled the grand space, the scent of old books and polished wood adding an air of authority and history. At the defense table, Karoline Leavitt calmly flipped through her notes, her expression giving away nothing. This wasn't her first time in court, but today was different. Today, she was up against Judge Walter Grayson. Known for his impatience and patronizing attitude, especially toward young attorneys, women, in particular, Grayson had a reputation that preceded him. The case itself wasn't making headlines, a contract dispute between a mid-sized firm and a former employee alleging wrongful termination. But Richard Calloway, the opposing counsel? A courtroom veteran who thrived on theatrics. The kind of lawyer who smirked before objecting, who played to the audience, even in a bench trial.
And today?
He had won. Karoline knew the odds weren't in her favor. She wasn't famous, she had no big connections, and she wasn't the type of lawyer who made the news. But what she was?
Prepared.
As the bailiff called the courtroom to order, Judge Grayson strode in, his robe billowing slightly as he took a seat. Adjusting his glasses, he scanned the docket, his gaze flickering from Karoline to Calloway before settling forward again. "Counselor Leavitt," he said, a hint of amusement tugging at the corner of his mouth. "Representing the defense today, I see." A polite nod. "Yes, Your Honor." He exhaled slowly, already looking exasperated. "Let's hope this doesn't turn into a law school seminar." Soft chuckles rippled through the gallery. Calloway allowed himself a smirk, making no effort to hide his amusement. Karoline? She didn't react. She simply straightened her posture and waited. Calloway took the floor first, delivering a polished, confident opening statement about fairness, corporate responsibility, and ethical obligations. His voice, smooth, authoritative, made even weak arguments sound convincing. He painted his client as a hardworking professional, betrayed by a greedy employer. And as he wrapped up, he cast Karoline a glance, half pity, half dismissal, like she was a student about to fumble through a classroom presentation. The judge turned to her. "Counselor, your response?" Karoline rose, smoothing her blazer. No dramatic pause. No throat clearing. No fidgeting with papers. Just her voice, steady and firm. "Your Honor, opposing counsel has presented a compelling story. Unfortunately, it lacks support, both legally and factually." The shift was immediate. Calloway's smirk stiffened. The judge tilted his head, as if only now considering that she might have something worthwhile to say. But doubt still lingered in the air. She could feel it.
Young.
Underestimated. A brief silence. A moment of stillness. Then, Judge Grayson exhaled, tapping his gavel lightly against the bench, as if debating whether to indulge her or dismiss her outright. "Ms. Leavitt," he said, folding his hands. "That was quite the opening remark. I assume you have more than just confidence to back it up." A murmur rolled through the gallery. A couple of interns exchanged knowing glances. Calloway barely suppressed a grin, shaking his head as if this was all a waste of time. Karoline remained unshaken. "Your Honor," she said evenly, "I would never presume that confidence alone wins cases. I prefer facts." The judge let out a short, condescending chuckle. "Well, that's good to hear. I'd hate for this to turn into a motivational speech." Louder laughter this time. Karoline ignored it. She reached for a document, her hands as steady as her voice. "If I may, Your Honor, let's talk about Colton versus Redbridge. A case that directly contradicts opposing counsel's claim that the termination in question was unlawful." Calloway scoffed quietly. "That case doesn't apply," he said dismissively. "Completely different circumstances." Karoline finally turned to him, meeting his gaze for the first time. "Incorrect. The precedent is entirely relevant. The ruling hinged on a key factor, the presence of a contractual clause limiting termination discretion. A clause that, in this case, also exists." Calloway blinked, for the first time caught off guard. Judge Grayson's expression remained neutral, but his fingers drummed idly against the bench, a sign. A small, telling sign. He was considering her argument. "Ms. Leavitt," the judge said, reclining slightly, "I appreciate the effort. But are you really suggesting that a single precedent overrides the fundamental principles of at-will employment?" There it was. The setup. He wanted to lecture her. Karoline didn't flinch. She flipped through her binder, pulled out another document, and held it up. "Not a single precedent, Your Honor. 5. Each reinforcing the same principle, employment contracts with clearly defined limitations cannot be dismissed under at-will doctrine. Would you like me to list them?" The room quieted. The judge stopped tapping his fingers. Calloway's smirk? Now noticeably strained. Grayson adjusted his glasses, letting out a long sigh. "Well, Ms. Leavitt, since you seem so determined to turn this into a law lecture, by all means, educate us." His sarcasm was sharp, meant to belittle. But Karoline took it as an invitation. She opened her folder, knowing full well what was about to happen. She lifted the first document, her voice unwavering. Preston vs. Briarwood Technologies, 2014. Despite an at-will clause, the court ruled that explicit contractual provisions on termination procedures take precedence. That case was presided over by Judge Holden, who, as you may recall, Your Honor, cited your own opinion in a similar ruling the following year. The shift in the courtroom was undeniable. Judge Grayson stilled, no longer tapping his fingers, no longer smirking. He knew the case, knew his own ruling had been referenced. Calloway, desperate, cleared his throat. "That's still not comparable," he tried. "That case involved a severance agreement." Karoline didn't even glance at him. She reached for the next file. Wells vs. Dartmouth Holdings, 2017. No severance agreement, just a termination clause requiring reasonable cause. The employer argued at-will discretion. The court ruled otherwise. Silence. Judge Grayson leaned forward. No longer dismissing. No longer patronizing.
Now?
He was listening. Calloway shifted in his seat. He had walked in expecting an easy argument. A few nods from the judge. A routine win. Instead, he was scrambling. The judge sighed. "Ms. Leavitt, that's an impressive list of citations. But let's be honest. Case law can be interpreted in multiple ways. Are you really saying these rulings eliminate an employer's right to terminate at will?" This was it. The moment.
The test.
Karoline didn't hesitate. "No, Your Honor. I'm saying at-will does not override contractual specificity. If a contract explicitly limits termination conditions, at-will doctrine doesn't apply, unless the language allows for it. And in this case, the contract states termination must be based on substantiated cause, with supporting documentation." She turned to Calloway, looked him in the eye. "Do you have that documentation?" The silence? Deafening. Calloway shuffled his papers. Looked. But Karoline already knew. He didn't have it. Because it didn't exist.